So it's 9 o'clock on our last day of hearing, which should be finished by 2 p.m. So you can be relaxed because you have time to catch your flight at 5 p.m. And unless there is anything else to consider, we can restart the cross-examination of Mr. Sally by the claimants. Hopefully you are supposed to take no more than 1 hour, hopefully less, but it's up to you. Provided that we finish by 2 p.m., everything is fine. And you need to take into account that there will be questions from the tribunal. So go ahead, please, Mr. Melsheimer.
Good morning, Mr. Asali. I want to go back to paragraph 87 of your second expert report. Yesterday we talked about the second sentence and about the mistake that someone in your office made about an exhibit called JAH 86. I want to focus on the first sentence of this paragraph. And could you read the first sentence, please?
Claro. Of course. In this specific case, it is not noticed that the claimants have included in the annulment proceeding the illegality of the administrative rescission of 821 for violation of 15.1R.
Did you write this statement?
No lo recuerdo, probablemente sí.
I don't recall. Perhaps I did.
Is that a yes?
Sí.
Yes.
What were you looking at when you wrote this statement that caused you to write it?
Lo que
What was discussed in connection with the rulings of the tribunal and also in the existence of 15.1R.
Well, you used pretty specific language that it wasn't clear to you, correct?
¿Me puede repetir la pregunta?
Please repeat the question. I didn't understand it.
In the first sentence, you state it wasn't clear to you whether claimants had asserted Clause 15.1R in the nullity action, correct?
No. Lo que
No. What I maintain is that in this case, it didn't exist. Not that there wasn't clarity in connection with the discussion of Clause 1.
I do not advierte, no veo.
It means that I don't see
that claimants made any argument towards Clause 15.1.R.
Your translation today is different than the translation you provided to us 4 months ago. In the English translation you provided to us, it says, "It is not clear that the claimants had asserted in their annulment lawsuit the illegality of the administrative termination of contract 821 for its violation of Clause 15.1R. You see that?
Yeah, I've heard that. I did not provide the translation. I did not do the translation. In this case, when it says in Spanish, en el caso concreto, it means in this case.
When did someone bring to your attention that you had made a mistake by citing JAH 86 in your second expert report?
I do not recall exactly, but before this hearing, when we looked at this, we saw that there was an error here in this citation. I made a mistake that did not exist, and I had to report it.
So were you reviewing what files when you discovered that you made a mistake?
Probablemente no lo recuerdo.
I do not recall exactly.
just so I understand, you're reviewing your second expert report in preparation of this hearing, and at that point in time, you discovered that you had made a mistake.
Pudo haber sido antes.
It could have been before. I do not recall. What I do have an exact recollection of is when I was conducting the review, it came up that there was a mistake.
Did anyone from the Secretary of the Economy alert you of the mistake that you made?
No.
No, I do not recall.
Hecho fue
In point of fact, this was a conversation at my law firm with people from my law firm when we realized that this was incorrectly cited.
Well, if you first learned of your mistake while preparing for this hearing, how would the Secretary of the Economy know about this mistake?
No.
No, I did not say that, Mr. Melsheimer. What I said is that when I was reviewing, I looked at this and I precisely recalled that we found out about this mistake. If the Secretariat of the Economy also discovered this and had internal conversations about it, I cannot testify about that because I have no knowledge of it. I assume that the Secretariat of the Economy looks at everything that is produced in an arbitration.
Yesterday, we talked about the good faith clause in Contract 821. Do you remember that?
Sí.
Yes.
And we talked about the expression totality of the works. Do you recall that?
Correcto.
Yes, correct.
Asked you several questions, and we finally, I believe, reached the conclusion that, in your opinion, totality of the works refers to the minimum contract amount under the 821 contract. Do you remember that?
Correcto.
Correct.
To save some time, would you agree with me that the 804 contract has a very similar clause in its good faith provision?
Correcto.
That's correct.
And so you would reach the same conclusion for the 804 contract, that when it refers to totality of the works in its good faith clause, that clause is also referring to the minimum amount under that contract, correct?
Es una interpretación.
That is a correct interpretation.
I understand you extensively reviewed the court files for each of the proceedings that are in dispute in this arbitration, correct?
Lo revisamos, correcto.
We did review that. That is correct.
So that's, yes, you reviewed them?
Sí, claro.
Yes, I did. Of course.
Have you seen any evidence in your review that Bissell continued taking any affirmative action before a Mexican court after March 2021?
I am not clear as to the dates, and I couldn't really say this off the top of my head. I don't recall. I don't know.
MWS.
Mismo caso, no.
Same thing. I do not recall.
What about Drake Mesa?
Igual.
The same thing. I do not recall.
2020.
March 2021. I do not recall.
What about Finley?
I do not recall.
What about Drake Finley?
Mismo caso.
Same thing.
I'd like to understand better your expert opinion about certain provisions of the 821 contract. Let's look at Clause 16, please. And if we'll give a chance for him to read the full, if you could read before, if you could just read the beginning, and I'm going to focus on parts B and then C. But I want to give you a chance to read the first part.
Cláusula 16.1, terminación anticipada del contrato. causas por las que PEP
Perdón.
I'm sorry. This is the early termination of the contract, and these are the reasons why PEP may terminate the contract early. PEP may terminate the contract early for any of the following reasons.
Focus on clauses B and C.
Do you want me to do that? ¿Las leo?
Do you want me to read those?
First, and then we'll have you read those too.
B, for not being able to determine the temporality of the total suspension of the works in the event that PEP orders the total suspension of the works in terms of Clause 17, suspension of the works, and it is not feasible to determine the timeline of the same, PEP may choose to terminate the contract early, communicating in writing to the contractor the effective date of the early termination of the contract.
In your expert opinion, what do you believe, or how do you interpret this clause to apply?
If a decision was made to terminate the contract early, if there is no breach by the contractor, PEP could determine that. If it couldn't determine for how long the works were going to be suspended. There's a difference between early termination and administrative rescission. This under Clause 16.
Do you agree with me that this clause works together with Clause 17 about suspension of works?
If it makes reference to it, yes, of course.
Do you agree with me that if Pemex needed to suspend works more than the time period estimated or anticipated under Clause 17, Pemex could invoke this clause to terminate the contract?
If the question refers to whether PEP could suspend the works, the answer is yes. If it had the possibility to do it, the answer is also in the affirmative.
Look at subpart C, if you could read that for us.
Claro.
C. In cases duly justified by PEP, in the event that circumstances arise that duly justified prevent PEP from complying with the contract, among which are when the contract is not profitable or suitable for PEP according to the economic model it defined, budget insufficiency, and insecure conditions of operation, PEP may determine the early termination of the contract by communicating in writing to the contractor the effective date of such early termination.
Do you agree with me that under this clause, if Pemex did not have sufficient funds, it could invoke this clause to terminate the contract?
Correcto.
That's correct.
What are the consequences, if you recall, of Pemex invoking this clause, 16.1?
The most obvious one is the termination of the contract. I'm sure there are others that I cannot recall off the top of my head.
Briefly, at 16.1.5. And we're on Exhibit R3. Could you read the first line of 16.1.5, please?
Pagos
Payments to the contractor in case of early termination of the contract.
So you agree with me that if Pemex were to invoke this clause under the circumstances we discussed, it would have to pay something to the contractor?
sí.
Yes, in the understanding that this clause provides that the contractor did not breach the contract in any way whatsoever. That is why an early termination is allowed. This is different from this idea of rescission under Clause 15, which provides for a rescission given the breach of the contractor. And I think this is what happened in the instant case.
You keep qualifying your answers about the contractor not fulfilling its obligations under the contract. Why do you keep doing that?
Porque
Because Clause 15, which is administrative rescission, makes reference to a breach. Clause 16 makes reference to an early termination of the contract when no breach exists.
y lo que entiendo
My understanding of what happened is that what happened here was a case of an administrative rescission and not an early termination of the contract.
Let's look at Clause 17 of the 821 contract. And let's read the first paragraph, please.
claro, cláusula
Of course. 17, suspension of work. PEP may temporarily suspend, in whole or in part, the contracted work in any condition that they may be in when the needs of the project or the contract so require, without implying the termination of the contract. When the resumption of the work is linked to a certain fact or act that is certain, but with an indeterminate date, the period of the suspension will be subject to the updating of that event without prejudice to the fact that the early termination of the contract may be chosen.
So I want to go back and make sure I understand how this contract operates. If there is a temporary suspension, Pemex would be allowed to invoke a temporary suspension under Clause 17, correct?
sí podría.
Yes, it could do that.
But if that period of time became prolonged, Pemex would be allowed to invoke its right under Clause 16.1.1b, correct?
Correcto.
That's correct.
How does Clause 17 operate in conjunction with the good faith clause, which is Clause 3 under the contract?
I would consider that the opposite is true. Clause 3, good faith, permeates the whole contract. It obligates the parties to act always in good faith within the provisions of the contract as established. Clause 17 refers to a factual situation. PEP could become obligated to this provision or under this provision if it had to ask for the suspension of the work.
Understanding your answer correctly, if Pemex were to find itself in a situation where it couldn't issue work orders, it had two options. One, it could have asked for a suspension of works under Clause 17, or two, it could have invoked its rights to anticipatorily terminate the contract under Clause 16, correct?
Eran dos de las
Those were two of the assumptions that Pemex could resort to in the case that you have pointed to me.
You were here for the testimony of Mr. Lustenau, correct?
Sí, sí. Correcto.
That's correct.
As a lawyer, in this situation where you are being asked to drill a well without a permit to drill that well, would you advise your client to drill that well?
I am not able to answer that question. The answer, according to what Mr. Lustenau said, I really don't know. I don't know the details. I don't know the full situation. I don't know if you could really do that perforation, that drilling.
So is that a no? You would not advise your client?
No, mi respuesta es no estoy capaz.
No, my answer is that I am not capable to provide an answer in that regard.
I'd like to talk a little bit about the 809 contract again. But before we do that, let's look at Clause 21 of the 821 contract briefly. Since we're talking about drilling a well without the proper permission to do so from the government. Could you read the first sentence for me, please?
Claro.
Of course, Clause 21, liability of the parties. The contractor will be solely responsible for the performance of the works and may not invoke as an excuse of responsibility acts of its subcontractors or suppliers, and must be subject to all laws, regulations, and ordinances of the competent authorities in construction matters, safety matters, use of public roads, environmental and ecological protection that govern at the federal level, state or municipal level to the safety and health provisions of PEP for the performance of the works established in Annex SSPA of the contract, and to the instructions that PEP indicates for this purpose, for which it is obligated to know the respective rules and regulations that apply according to the works subject matter to this contract.
So you agree with me that under Clause 21, the contractor under the 821 contract would have been responsible, and the only one responsible, for drilling a well where there was no drilling permit to do so?
Yes, but this clause is designed to avoid the contractor to hide behind subcontractors or suppliers. PEP and the contractor establish a relationship, and the responsibility is with the contractor, and you cannot hide behind a provider or a subcontractor.
Now we'll proceed to the 809 contract. And that's going to be JAH 63. And specifically, I'm going to refer to the finiquito for the 809 contract. And I'd like to look at page, I believe it's 6, paragraph 2, Romanet 1. And that's Romanet 2. Could you read, if you will, 2 and then Romanet 2?
Of course. 2. That collections are pending in its favor, amongst others, those arising from the recognition, authorization, and payment of the following. The issuance of work order, this is Romanet 2, the issuance of work orders by PEP in order to comply with Clause 5 of Work Contract 424043809, that establishes a minimum budget of $24 million because in the contract, the recognized amount to date was only $8,432,522.30. And the difference is still pending between the amount used and the minimum amount of $24 million.
So you agree with me that the contractor from the 809 contract was also not receiving work orders under its contract?
Sí.
Yes.
Let's go to the next, and just to look at the date. I believe this was August 2015. And we'll show you just, I'm not trying to trick you. You agree with me that this finiquito was dated August 21, 2015?
Correcto.
Let's go to
That's correct.
the document called Acta de Circunstanciada, which is Exhibit C62. Just so we go in order, let's start at the top. You agree with me that this document is dated April 9 of 2018?
Correcto.
That is correct.
Let's look at page 2, paragraph 4. And you agree with me that this is between the contractor for the 809 contract and Pemex?
Correcto.
And the
That's correct.
Pemex's letterhead, right?
Correcto.
Okay.
That's correct.
So if you could read, and for the sake of time, if you want to read the first part of paragraph 4, you can skip Romanet 1 and then continue to Romanet 2.
Dice, el 21.
It says, on 21 August 2015, the parties drew up a acta de finiquito of contract 42-40-43-89, with the contractor reserving its rights in Clause 12, representations of the parties in order to exercise them before the various competent authorities in time, place, and manner as best suits its interest, leaving safe its rights to collect the credits and/or balances that arise in your favor from the claims. In addition, the contractor stated that charges are pending in its favor, amongst others, those derived from the recognition, authorization, and payment of the following. 2. The issuance of work orders by PEP in order to comply with Clause 5 of the Open Work Contract, which establishes the exercise of a minimum budget.
Let's continue to page 3. Paragraph 7. Could you read that for us, please?
Claro.
Of course. On March 22, 2018, through official letter PIP GSIAP of 2018, the coordination of services for intervention of the northern area wells asked the engineering management for cost to rule on expenses, not recoverable amounts, and extraordinary unit prices corresponding to the payment of waiting times due to lack of work order assignment. On April 3, 2018, the Superintendency of Cost Engineering of Costa Rica issued a results for the review of non-recoverable expenses and extraordinary unit prices through official letters indicating the following. The extraordinary unit price that was determined from the Superintendency of Cost Engineering in Costa Rica as indicated below. and it says $42,167. Item is 223. The description is availability of drilling personnel and equipment, and the U.S. Number in dollars is 42,167.14. This amount corresponds to non-recoverable expenses and that were determined to come from the Superintendency of Cost Engineering of Costa Rica, which were motivated by the suspension of work and the estimated amount of non-recoverable expenses.
So if I'm reading this correctly, Pemex decided to pay a rate of $42,000 a day for the days in which it did not issue work orders, correct?
No, es incorrecto.
That is incorrect. This payment, as it is clearly stated here, had to do with a review of non-recoverable expenses. And Bissell and MWS, the contractors, did the same reservation of rights under the finiquitos. It didn't really have to do with a minimum amount under the contract, but it had to do with the non-recoverable expenses. This was the $42,000.
Page 5, the amount. Look at that first column. Where's it segundo and primero? Those bottom two. Can you read the second agreement?
La cláusula segunda,
Please.
The second clause
derivado de la
that derived from the lack of assignment of work by PEP during the exercise of Contract 42-40-43-809, PEP recognizes the economic effects for the contractor up to the amount of $13,493,484.80, which integrated as follows.
$1 million number was calculated?
no de memoria, supongo.
Not by heart. I imagine that is what is under the contract, and there will be an important and significant amount of non-recoverable expenses.
A previous provision of this agreement to help refresh your recollection. This is part of the calculation. Would you agree with me that for each equipment, Pemex agreed to pay a rate of $42,000 for each day that the equipment was not used?
No,
I do not know. I imagine that you're telling me the truth. I have no reason not to believe what you're telling me.
See the page before?
no, sí.
If you want, you can show it to me.
We'll go back. Again, we were just looking at the chart that was following the paragraph that you read. Segundo.
Sí, pero me parece que
Yes, but I believe that in order to understand the number, the figure that you want me to recognize, we need to look at all of the agreements. If I read the first one, it refers to fortuitous event or force majeure. It refers to suspension of work. The second one has to do with economic impairment during the performance of the contract. I do not believe I should not providing any service. It would be a disservice to this tribunal if just by reading one clause I agree with you on what clearly is related to the reading of several clauses, as I mentioned before. from what I recall from the analysis and from also what I saw in my reports, the amount that was covered derived from 809 had to do with non-recoverable expenses rather than the payment of the non-minimum amount based on the agreed amount on the contract.
Have you done a calculation? And you referenced I believe you referenced force majeure. Have you done a calculation on the total amount that was paid to the contractor under the 809 contract? What percentage of the payment corresponded to force majeure?
La respuesta es no he hecho.
The answer is I have not done that estimate.
If I told you it was approximately 10% or less, would you have any reason to disagree with me?
Ninguna.
None.
I want to show you another clause in the 809 finiquito. If you could read the third paragraph under Agreement 4 of this finiquito. Circunstanciada.
Entonces estas, en esta.
Please.
So here,
Cláusula.
fourth paragraph 3. For this reason, it is agreed that once payment is made by PEP to the contractor, the deed of extension of rights and obligations will be formalized in order to conclude this contract.
So do you agree with me that when Pemex agreed to this acta de circunstanciada, it did not believe that the 809 contract had concluded when it entered into the finiquito for the 809 contract?
No, me parece.
No, I believe that the text here is a little bit, or the drafting is a little bit unfortunate because the contract was already concluded before the finiquito, but the party that drafted this document used an incorrect expression. The contract ended with the finiquito, and the obligations derived from the finiquito are the ones that are still in force in the relationship between the parties, and this act for the extension of rights led to extinguish any obligation derived from the finiquito in all
of this document. Would Mr. Epitacio Solis Fuentes be able to explain what you claim to be a mistake in this acta de circunstanciada?
No creo que se
I don't believe it is to be qualified as a mistake, but it is an unfortunate draft. I imagine that Mr. Epitacio Solis Fuentes would agree with what I just mentioned.
Mr. Epitacio Solis Fuentes still works at Pemex?
lo desconozco.
I do not know. I do not know Mr. Epitacio Solis Fuentes.
When we started this arbitration, I had one document with respect to the 809 contract. How did you get the documents related to the 809 contract that were included in your expert reports?
Creo que
I think that we discussed this yesterday. We received from the Secretary of Economy a file with the key documents. For my opinion.
H63 and J. I'm referring to JAH 63 and JAH 2866. If I understand your testimony correctly, someone at the Secretary of the Economy gave you these documents.
Correcto.
Correct.
So would you agree with me that the Secretary of the Economy has access to more documents that may be similar to these?
No lo sé, habría que preguntárselo.
I don't know. You need to ask the secretariat.
We talked about the administrative court action or the nullity claim with respect to the administrative rescission of the 821 contract, correct?
¿De acuerdo?
Yes.
If the contractor had told the administrative court that work order 28-2016 was generated, or actually, let me be more precise, that the authority had fabricated work order 28-2016, would that be something important for the administrative court to take into consideration?
Sí.
Yes.
Thank you, Mr. Asali.
So you are done for the time being. So now is Señor Monfiglio redirect.
Señor presidente, nos concedería
Mr. President, can we have a minute to review our notes?
Estamos listos, señor presidente.
We're ready, Mr. President. Thank you. Mr. Asali, we thank you for your time. Claimant's attorney asked you questions about a typo in your second report, and you were also asked about the documents from the nullity proceeding 2017. For the benefit of the tribunal, would you please explain what you understand by a brief to expand the case presented before the court, yes, clearly the cause of action is clarified, is expanded, and so that the tribunal, the court, has all of the necessary documents, all of the necessary information from the beginning of the case, so as to take cognizance of the case and also to provide the state, the respondent, the possibility to defend itself and also to get to know all of the accusation or the case that is being, or the subject matter of the claim. It is a formal pleading that is presented. So we can say that the inclusion of the additional items to the complaint should also include the case and the claim. Yes, it is part of the statement of claim, and it determines the subject matter of the claim to determine the petition or the claim, and at the same time, the respondent gets to know the case and also to present its defense or prepare for the defense. And based on your explanation and also bearing in mind the 2017 nullity proceeding, would you please explain to the tribunal whether Drake Finley had an opportunity to include additional items to the complaint? Of course they did. Every respondent has the possibility to do so, to present all of the briefs and remedies at their disposal. Of course, they had the ability to do it. Thank you. Certainly, you may not remember off the top of your head the number of the exhibit for the nullity proceeding judgment, but that would be RZ39. That is the judgment of the nullity proceeding of 2018, and I understand that you analyzed it in your reports, for your reports. My question is, from the analysis of this judgment and also from analyzing the documents of the 2017 nullity case, do you know if the claimants in that case, Drake Finley, included additional documents to the complaint? No, they did not. Thank you. Claimant's attorney asked you some questions about Clause 16 under Contract 821 that has to do with early termination. For the benefit of the tribunal, would you please explain the difference between a provision on early termination on the one hand, and on the other hand, the difference with the administrative termination? Yes, I attempted to do so in my early responses. Early termination does not assume non-compliance of contract provisions. This is a power that Pemex has, that under certain presumptions under the contract may terminate the contract early without the need to have any non-compliance by the contractor. But rescission implies non-compliance with some of the obligations that are part of the instrument, and also empowers Pemex in that case to rescind, to terminate. And one is in its strict sense, and the other one is a little bit more flexible, the contract. And also when we refer to early termination, Pemex has the obligation to cover certain concepts without the need for non-compliance by the contractor. Thank you very much, Mr. Asali. I need a couple of seconds. Mr. President, we have no further questions as part of the redirect. Thank you very much, Mr. Bonfiglio.
Mr. Conte, can I just have a question?
Sure.
It's just a procedural, and I may be unfamiliar with the process here. Is it normal for part of the experts team to consult with Mexico's team before asking questions? Is that a normal process?
For Mexico's team?
Correct, to consult with part of Mr. Asali's team. I think there's two members of Mr. Asali's team here. I just want to make sure we're all playing by the same rules. Is it normal, is it proper, maybe a better question, for them to consult with Mexico's attorneys before questions are being asked to their colleague as an independent expert?
Well, I was not aware that podría quizá responder.
Would you please answer this question, Mr. Bonfiglio? With great pleasure. I imagine that claimant is here represented by attorneys who are aware of international law, who are cognizant of international law. When respondent sent a list of participants, we indicated that 2 members of the Asali law firm would be here with the Mexican delegation. This is to support Mr. Asali in case it was necessary. But at the end of the day, there is nothing incompatible with the arbitration practice, and we would like to say clearly that Mr. Asali was separated yesterday. He was under sequestration order. So we were very transparent with our list of participants, and claimant has had it for days. If the specific question by Mr. Melsheimer has to do with whether to prepare a redirect question, we can consult quickly with the team of the expert being examined. I do not see anything that is inappropriate, and I do not understand this comment by Mr. Melsheimer, and out of efficiency, we should continue with the agenda.
I don't know whether my colleagues...
I would have just a follow-up question. Would you not agree with me that the assistants or the people who belong to the firm are part of the team, and therefore if there is a sequestration rule, it does apply to his team as well? So you may not talk neither to him nor to his team before you make any further question, unless it is open here on the floor. That's the only communication that you're allowed to have, the one that is on the mic, and it's with him only, or if it's with people from his team, it should be also in the public.
Gracias por su comentario. Voy a ser más claro.
I thank you for the comment, and I'll be clearer. The only person who is here appearing as an expert on behalf of the Mexican delegation is Mr. Asali. He has been under sequestration order since yesterday. He has had no communication with us or with his team. He arrived here this morning and he was still under sequestration orders. So the person that is being examined today is Mr. Asali and not Mr. Asali and his team.
You, between his team and him, since the moment that he left, or the cross-examination was finished yesterday.
Es correcto, señor Stinnerman.
That is correct.
Well, I think we can continue with the questions from the tribunal. Alain.
Well, I would like what the claimants wish to obtain from the tribunal. My position is that Ms. Aguilar was listed as an expert, not a member of the respondent team. But that being said, what consequences should we draw from that? Because from that, honestly, as far as I can see, it was really for the very last minute, and I don't think it is une erreur substantielle. But well, I would like to know what you expect from this, if you think I am correct. What can we do now?
Your observation is correct. I did watch Ms. Aguilar participate in a side chat with Mexico's attorneys. I don't know what the consequences are, but I think it's highly inappropriate.
Señor Presidente, lo digo con mucho...
Mr. President, with due respect, if something is inappropriate, is for individuals in this room to be here without any sort of authorization. We have been very respectful, but there is a person here who we don't even think who that person is. I am going to leave my comment here so as not to make a great fuss out of it, but claimant is asking for something that they don't even know what it is, so we do not understand.
We're going to pass judgment on this particular event, and we'll reflect on it, and we'll continue with questions now from the tribunal. If I have a few, but probably my colleagues have as well. And Alain or Franz, you want to start?
It should be him that time.
Okay.
Not necessarily.
No, okay, then I will be the first one to raise issues.
I was saying that I am happy you were able to survive sequestration and this examination that you are being subjected to. Now, let us look to your first report, where you also told us or showed us a pyramid at paragraph 82. Paragraph 82, page 29.
Este parrafito, no sé si alguien, bueno, no hace falta, yo creo que lo exhiba, y es un poco continuación de una pregunta paralela.
And this is the continuation of a parallel question that I asked Mr. Amezquita after I saw the non-judicial nature of the Federal Court of Administrative Justice. So maybe someone can show page 929, right above paragraph 83 from the first report by Mr. Asali. As we see it on the screen, there is a pyramid, and there seems to be a hierarchy of the judicial system, but as we saw yesterday with Mr. Amezquita, and at the bottom of the pyramid, the Federal Court of Administrative Justice is not part of the judiciary, rather is part of the executive. Correct. So it is clear that the Supreme Court of Justice of the nation is within the judiciary, and the intermediary level, the collegiate circuit court in administrative matters, is it the executive or judiciary? The judiciary, Mr. President. Then it is clear that the Federal Administrative Procedural Law follows the French system, which is quite different from the common law, whereby within the executive there is an organization that is not the judiciary, that is the one that has the power, such as the system created by Napoleon, to review the administrative acts and declare them null, or to determine whether they are null or not, but that is not the judiciary. So it is the executive that is delegating on an autonomous body the power to review the potential nullity of administrative acts. Correct. And always towards the end, such a determination may be analyzed by the judiciary. The final decision is not with the judiciary, with the executive. So once it is a challenge to the annulment, it goes back to the judiciary. So if I understood Mr. Amezquita properly yesterday, I understood that the Federal Court of Administrative Justice has full jurisdiction. It can look into all of the aspects of the case, but for the amparo remedy, whenever it is sent back to the Supreme Court of Justice or the Collegiate Circuit Court, there is no full power because they need to determine whether there has been any damage to a constitutional right to the amparo petitioner. But the amparo tribunal, the amparo court, needs to review, analyze the acts based on what the lower court studied. So it doesn't mean that it cannot review all of the acts, and so that is based on the proper motivation of every judgment. If the lower court did not properly analyze the claim, the lawsuit, the amparo court may say this is going to be resolved as in a way or the other, but they cannot analyze novel situations that are different from the ones originally presented. And to this we add that the same arguments cannot be reiterated, but the judgment that has been passed by the lower court has to be analyzed to present other elements by the higher court and decide.
The collegial circuit court, is it a full appellate court where, well, this is the case in Spain, a court of appeals can review the entirety of what was determined by the court of first instance? I understood, because perhaps the expression amparo, I understand that in Mexico and many other countries, this is related to violation of a constitutional right, which means that when it takes cognizance of an amparo proceeding, only takes cognizance of those aspects that may be at odds with the Constitution, but not other possible violations that are not constitutional violations. There's only protection of the constitutional right that the complainant, the amparo petitioner, has, but one does not get into the entirety of the judgment on first instance. In this case, the Federal Court of Administrative Justice, unlike what happens in other countries, for example, in Spain, on appeal, there is full jurisdiction, and the appellate court practically begins a de novo review. The amparo petitioner cannot argue new facts that were not argued below, but with the facts that were argued, the court on appeal can examine not only constitutional violations, but everything. So in Mexico, is the collegial court an appellate court with full jurisdiction, or is it limited to violations of constitutional rights? It can get into any issue that was analyzed by the lower court. Why? Because one is protecting the constitutional right to proper foundation and reasoning of the act of the authority. The question is to know it. Well, I don't know if know it is right, but how to ask for it, insofar as one, as the amparo petitioner, asks that the court properly study what transpired in the court below. Then, as a practical matter, it can analyze everything related to the judgment of the lower court. That's why my question was whether in Mexico the review of administrative acts, a full review, is it just in one instance or more than one instance? Now, I understand that amparo, for practical purposes, is a full appeal. Yes. For practical purposes, that the amparo court can study all aspects where the failure to state the rationale or reasoning has put forth by the amparo petitioner, enables the court to get into it. Now, we had said that we'd have a discussion where the tribunal would put questions to you that you could address in your post-hearing briefs. I think this might well be one of them. Let us now go on to the question of the finiquito, which you address in your second report. First, at paragraph 26, when in your second report you say that the finiquito, and this is at page 12 above, if you have your own report, the finiquito as an administrative act that is independent with respect to the contract. You speak of 803, but I suppose that would apply to any finiquito. The finiquito, well, that is why my question. Do you maintain that it is an administrative act. It is not a contract, nor is it part of the contract, but rather it is an administrative act, and therefore subject to the regime that governs administrative acts. That is how the abrogated or repealed PEMEX law, its regulations, and the docs define it as an independent act whereby the rights and obligations set forth in a contract will be that there will be a transaction in respect of which the compromise where the rights and obligations that result from the finiquito shall govern as between the parties. And now if you take me to one of the cases that we analyzed in the opinions, 803 in particular, when PEP is summoned to the proceeding, it says the finiquito hasn't been analyzed. This act was not analyzed. Hence, it asked the district court judge to review its jurisdiction once again, resulting from the finiquito and from an administrative act, which is what the finiquito is. So, to be specific, it is an independent act according to the law and according to the regulation, but under which the parties will continue their legal relationship based on what's agreed upon in it. If we turn to page 38 of your second report, where you speak of the finiquito of Contract 821, there you say that the claimants also argue that Contract 821 continues in force given that, and this is the part I'm interested in the Finiquito Act formalized in November of 2021, PEP set forth an amount owed to the contractors for $41.8 million. So in the Finiquito, which was drafted unilaterally by PEP, there was a quantification of the bond. So my question is, that quantification of the amount owed due to the contractual penalty entailing enforcement of the Dorama bond, those $41.8 million, that was an administrative act subject to appeal. Yes. Other than rescission. So we have an administrative act there other than the rescission whose date was 2021, November of 2021. Yes, sir. It could have been challenged. It was susceptible to a challenge. Yes, the finiquito that was issued or formalized on 10 November 2021. Okay, and couldn't one say it's an administrative act, but because it is caused by or related to the rescission that was from 2017, actually you can't challenge it because the action is time-barred. Since you already challenged the 2017 rescission, you are prohibited from appealing a new administrative act that is based on the one that already went before the administrative courts. I think those arguments are valid if one decides to challenge this finiquito. I suppose, because I can't know this, that PEMEX, as a matter of bureaucratic administrative issues, found it necessary to draw up this finiquito certificate as a requirement for demanding enforcement of the Dorama bond. The actuality is I don't know. If you ask me, strictly speaking, was it necessary, this finiquito? My immediate answer is no. The contracts had already been rescinded. Why did PEMEX do it? Well, I tend to think it was a bureaucratic issue in order to close out the file so as to be able to require contractual penalties so as to determine balances pending. The contract had been rescinded as from 2017. Of course, that is why what you say is very interesting. The contract has been rescinded, but the rescission of the contract in the 28 August rescission decision, the amount of the contractual penalty due to rescission is not specified. And unless the parties correct me, I think the first time that in a document after the May 2018 meeting in Villahermosa, where there was talk about the amount of the contractual penalty, the only administrative document where that quantifies the conventional or the contractual penalty was the finiquito in 2021. I say this because as we've been speaking of periods of prescriptive limitations periods for the purposes of this tribunal. We have an administrative act here of 10 November 2021. Yes, okay. Now my next question goes to an issue that we've analyzed ad nauseum, which is the famous clause 15(1) R and S. Your colleague, Mr. Amezquita, the other day, or yesterday, he used an expression saying that clause S is a shoemaker's box or a tailor's box. Would you agree with that characterization, or a catch-all? It's generally said so because everything possible in a contract fits therein or thereunder. What I don't agree with is his interpretation, which is that that one should have to update at least one aspect of that clause in order to apply S. I think the clause is quite clear in the heading where it says any non-compliance or breach of any of the provisions set forth in the clause could give rise to rescission. In the specific case, the court verified the breaches and confirmed them. The drafting is clear. Any would be sufficient for administrative rescission. And where I agree with my colleague, Amezquita, is that this is due to this exceptional regime that the contract enjoys because of the handling of public resources by PEP and the need to always see to it that such resources be handled in a manner that is constitutional, that is, say, effective, efficient, economic, honest, and transparent. That is what our Constitution says. Well, I say so because I know that, well, in Mexico, these expressions are used for catch-all, shoemaker's box or tailor's box. In Spain, these expressions have a connotation of a residual clause or a closing clause. I've been a regulator and supervisor, and there were often grounds for imposing a penalty or sanction on a financial intermediary. And if the subsections of Clause 15 were clauses for imposing sanction on a financial intermediary, at least in Spain, it would be unthinkable to impose a sanction on someone under 6 for something, or under S for something that is under R. An authority might say, I'm fine you because you've breached this once, but the previous section says that one can impose the sanction once there have been 15 violations. So the canon of interpretation of the effet utile of clauses, if one can impose a sanction under S, what would be the useful effect or effet utile of clause R? In my view, clause R established a specific number of breaches that the judge, the adjudicator, never had an opportunity to analyze. I don't consider myself in a position to say or give an opinion as to whether the contract was or was not properly rescinded, but I do feel able to say that if the judge, with what he had before him, reached a adequate decision in light of my interpretation, well, I think if your question is limited exclusively to the content of the contract, it would appear that 1 would not have been sufficient, mindful of Clause R. Now, I understand that the judge and Pemex did not invoke just 1. They referred to obligations relating to the environment. They also raised the issue of sanctions on the contractor because of a change in domicile. So it was more than just S. Now, if the judge relied on S, well, one would have to ask him about that. But once again, as the judge took cognizance of the controversy, he judged it. Yeah, yesterday you said something that I thought was quite important, being in the judicial milieu all the time. An adjudicator cannot be a Hercules and necessarily sift through every single document. The judge needs the lawyer to lead him through the path to the best possible resolution. It was said years ago that a bad judgment is not the result of a bad judge, but rather a bad lawyer who did not know how to lead the judge down the proper paths. I am a firm believer in this. You can't require that one know 10,000 pages of a document if it was so easy to say, watch out with, focus on this one. That is my opinion, sir. I should recall that the reference to Hercules was not my own, but Dworkin's, the Judge Hercules who knows everything and is on top of everything. But you've said something quite important. Let us imagine, as a matter of hypothesis, we're always coming up with hypotheses, that there's been no violation of the PACMA and that the person responsible for PEMEX was easy to locate and the domicile notified. In other words, that the other grounds invoked by PEP for its resolution of 28 August were not present, that the only ground were Work Order 28 of 2016. If I've understood you properly, you have come to say that in that case, one could not have resolved the matter under S. There was a more specific one, which was R. I think it would be complicated to reach a judgment of liability in well, more than that, I think it's complicated for the judge to maintain the validity of that act with a single breach. But that means then that the rescission was based exclusively on the breach of the PACMA obligation and the notice, because if there wasn't, if R wasn't satisfied, and if, as a matter of the work orders, it was R that had to be applied as a matter of priority and not S, and the judge or the court declared annulled, that means that it put under S the other alleged violations noted by PEP, which was change in domicile without notice and the failure to carry out the PACMA obligations. Answer. On the one hand, you have the PEMEX actions, and on the other hand, the obligations of PEMEX and the those of the adjudicator. If PEMEX thought it was in a position to rescind, well, that was up to PEP, and PEP said, based on A, B, and C, I go forward with administrative rescission of the contract. Now, the opportunity to challenge and complain of that ruling was up to the contractor. How the contractor made use of its rights to challenge that rescission is a matter independent of PEMEX. And that is what the adjudicator had to go by when judging the dispute. Did PEMEX put forward sufficient grounds to defend the resolution, or, on the other hand, could it be that the contractor did not draw sufficiently on the grounds for annulment to support the injustice of the act? Well, the adjudicator reached a decision which, I reiterate, was approved by the superior, by the judicial branch, on analyzing the judgment that was challenged. Yes, but even if Mr. Rafael Ansúrez Uribe, who wrote the decision, was not Hercules, he's a great judge. Well, Mr. Mesquita knows more about political matters than I do, but he's a great jurist. He was a professor of both of us, I suppose. Well, even if he wasn't Hercules, and despite his professional status, when he saw the rescission, he said, PEP, as regards the work order, you cannot invoke S because the contract includes a section R. And even if it hadn't been argued by the Amparo petitioners, the judge and the court had to read the contract, and they said this doesn't fit under S because S is a catch-all. And since there's a more specific item, which is R, you can't put rescission for breach of the work order under S because R has priority. Is that not so? I don't agree. I don't know how the judge, Rafael Ansúrez, acted, proceeded when he resolved the dispute. But I don't see it like that. I reiterate, for me, the responsibility of any moving party in any legal action must know how to put what they're requesting to the judge, also for another reason. If you strip away the whole controversy, and we say, at what moment was PEP able to defend itself from there not being 15 breached work orders? It seems to me that the reason why the dispute was focused the way it was to make sure that the respondent would not be defenseless so that PEP could defend itself. I don't know if PEP had 14 others in the drawer, but PEP never had to defend itself from that because it was never raised that 15 work orders were needed. And once again, we're stripping everything away and leaving just Clause R. So it seems to me that this question of defining the scope of the dispute is so important so the respondent knows what he has to answer to and not leave him in a defenseless situation. Had it been said the act is null because you didn't accumulate 15 work orders that were breached, and then PEP could have said, when was I accused of that? When did they use that clause to defend themselves? I'm being left in a defenseless situation. I'm not being able to defend myself here. So I think that one gets into a chicken and egg question, which came first, and that's why it's so important to define the scope of the dispute, to clearly establish the concepts and the defenses that each party has. And in this case, it's evident to me that there was no claim on the part of the contractor for 15R. So you don't think that the court sua sponte couldn't have denied it, the rescission, by looking to, by saying S doesn't apply, R applies? You believe this is subject to the need to request justice. In other words, if it's not been argued by the amparo petitioner, then the court doesn't have to say R prevails over S. Yesterday, an interesting point came up. In 25 years, I've only seen one time a court in Mexico invoke a legal ground different from what the parties put forth to resolve a dispute. I think that a judge can do so, but it's extremely unusual and rare for that to happen. Now that you said it, it's crystal clear to me. 25 years, any number of judgments. Only once did a court say, it's not over here, it's because of this other article. And so once again, I reiterate, it can be done, but I've never seen it. Well, one time. But the one that could have done it would have been the court. Yes, the court. Very well. Now let us go to the suspensions and intermittent orders. And let's see if someone could show RZ 39 at pages 228 to 233, because when I read the judgment, these pages strike me. Let us go to page 228. We Spaniards have that vice of speaking fast. I will make an effort to speak as slowly as I can. Page 228, yes. This page says, now, the claimant's argument has no foundation when it argues that the work was intermittent and that there were several suspensions of the works. First, because it doesn't prove its assertions. And then what strikes me is that 5 pages follow showing official communications that speak of suspension. This is page 228, 229, 230. And it's at page 233 that there's any number of official communications mentioned that speak of the non-continuation of work, and the court reaches this conclusion. Based on its content, it does not appear clearly that the respondent authority has suspended performance of the work, for one only notes PEP's recognition that it doesn't have budgetary sufficiency and that as a result it must communicate to the service provider companies that once the drilling program is concluded, they should dismantle and transport the drilling equipment to the respective bases. Now, do you consider that this is consistent with the 5 pages that come before of official communications that speak of suspensions? It occurs to me, and I shared this thought yesterday, that we should distinguish between de jure suspensions under Clause 16 and de facto suspensions, which were suspensions, in fact, but where PEP did not declare the suspension under Clause 16. That is why I was asking myself whether what the court wants to say here is that it has suspended under Clause 16. My reading would be along those lines, Mr. President. It seems to me that the court is saying that there are no de jure suspensions. And if I'm remembering correctly, and turning to the civil complaint in 821, the contract clause made reference to de facto suspensions. It seems to me that this could give rise to some confusion, for legally speaking, the only term suspension, it applied only under Clause 16, which you mentioned, and that did not exist in any of the cases. So it seems to me that this refers to a de facto suspension more than a de jure one, and that the de jure suspension did not exist. Well, even if we go back to page 228, the court says not only that there were not suspensions in a contractual sense, but rather in the sense that the work was intermittent. So the court appears to understand that the works works were not intermittent, but were continuous, and this strikes me because it goes against the very evidence that the court adds with those 5 pages of official communications. And it seems to me that it's clear that the work orders were intermittent. They were not continuous, but rather they would happen over time. Now, the time for carrying out the works, which was clearly agreed upon by the parties, went until the end of 2017. Now, I don't know the reasons that led the contractor to seek early termination of the contract, but at that time the contract was still alive, it was still in force. And so PEP still enjoyed several months, 16 months, I'm not sure how many, to continue issuing work orders. Yes, but whether one did or could foreseeably reach the minimum sum of the contract. We're not talking about the mere interruptions. That's why I was asking whether you saw any explanation for paragraph 233, and I think you'll agree with me that the only possible explanation is that here the tribunal or the court is talking about suspensions in the meaning of Clause 16, which, as we saw, was a power that PEP alone had, and that the contractor could not trigger because the contractor could only ask for a suspension once it had done the work under Clause 17, with which PEP had in its hands, well, with which PEP never had to suspend the contract. But I think that's been clarified. And I wanted to ask you another question that I had forgot to ask. We understand that the Federal Court of Administrative Justice is an organ under the executive branch. Mr. Rafael Ansures is an eminent jurist, but I understand then that he is not part of the Judicial Career Service. Correct. And my question is, how are the judges of the Federal Administrative Justice Court designated, and what is their professional career path? I understand that it is at the request of the executive that appoints them, and they need to go through a process of veto and vote to be ratified in the position. My knowledge in this regard, I fear, is not strong enough to help the tribunal, but it's the executive proposes them to occupy some position, and I understand that they go through a process of veto and vote, but I don't know the details. This is a delicate matter, but it's important. In Spain, for example, we have a debate regarding the politicization of justice, and in Spain it's always been said that judges who wanted to do well in the judicial system, insofar as their appointment is determined by the General Council of the judicial branch, made up of members who are designated by the government, by the executive, well, their conduct when it comes to handing down judgments may have effects on the development of their professional career. And my observation, and I understand that this has to be handled carefully, to what point are the members of an organ such as the Federal Court of Administrative Justice, even if it's tacitly or unconsciously, to what extent might they have an incentive to hand down judgments which are always respectful of legality, but which, insofar as possible, approach more the interests of the executive than the interests of the contractors?
None of those, Mr. President, and I'm not concerned about being wrong. Two reasons. All decisions are going to be examined by the judiciary. They can be challenged at the judicial level. I spoke to adjudicators in Mexico, and none of the ones that I have spoken to would want to see their judgments overturned. So if the ruling is defective, that ruling may be overturned, and no adjudicator wants to see their judgments overturned. In my professional experience, the state generally loses because the amount of work that the government lawyers have, the workload of the government lawyers is enormous. So the private party can always go to the judge and be more ready, be nicer before the judge to assert the case. So basically what happens is that the state ends up paying because it loses the cases. That's my experience. Throughout your reports, you use the same expression that Mr. Amezquita used, meaning that administrative contracts have this idea of extraordinary powers, the exorbitant powers. And you say that this is what allows for the rescission to take place. The rescission can take place, yes, without going to the courts. In the PEP contract, it was acting as a public authority, right? Or vested with powers that were born from public regulations, so not as a private party. I said, or I think rather, that it was vested with the powers that PEP has to handle public resources. I wouldn't say it is a public authority. I think that Mr. Lustano was very clear. He said that Pemex is not part of the organic law of the public federal administration. Pemex is a company that, under the Constitution, should provide value to the investments it makes. Pemex has its own personality, legal personality, its own assets. If I stake a claim before, or rather in connection with the Secretary of the Economy, well, the Secretary of the Economy doesn't have an asset base, or it doesn't have a legal personality. Pemex does. A rescission is an administrative act that may be reviewed by the courts. You said that finiquito is another administrative act. Is it possible that someone that is not a public entity exercising public powers issue administrative acts that may be reviewed by the administrative courts? Because that would mean that you are vested with public authority, that you are not acting as a private party, that you are not trying to get electrical power. But when you issue a finiquito or a rescission, that is an administrative act that may be reviewed by the courts because the issuer of the act is a public authority. I agree. I'm going to give the floor to my colleagues now.
Arbitrator doesn't want to take the floor first. I don't really care. Well, first let me say something for the record. When the French Conseil d'État acts as a judge, it acts as a judge and fully, totally independent, to the great regret of the government usually. And then maybe I could ask you the question: is that the same for the administrative court?
Sí, señor.
Yes, sir.
Let's go to something else. Well, yesterday I was a bit surprised that you agreed that easily with Mr. Melsheimer that you had not dealt with Article 15.1 in your first report, because in fact you did. In particular, I think I refer to, in particular, to paragraph 59. And I think your idea is clearly that the grounds in Article 51 are alternative and not cumulative. Let's assume that. But when you interpret a contract, all the clauses must have some effect. So I would like to know from you, and maybe it would be also a question that would be interestingly dealt with by the parties in their post hearings. I would like to understand from you how you can give an effet utile to both clause RS, also F maybe, of the contract. With how can you reconcile those? Each must have an effet utile. So how do you give it? How do you define the effet utile of those three? Nobody has spoken virtually, I think, of F, but for me it's also one subparagraph which could have some contradiction with R or S.
No sé si podrían exhibir.
Could you please show on the screen 15.1? In connection with your first comment, sir, I agreed in the sense that I made no reference to 15.1R, specifically R, subparagraph R, in my first report. The question posed to me was why I did not address subparagraph R. And that's why I agreed, because that was not specified there. In connection with the interpretation of F, and let me read it right here. And if we look at F, we see if the contractor unjustifiably interrupts or abandons the work or refuses to repair part of them, I don't know why Pemex did not assert this in the rescission in light of what Mr. Lostanon said, but
I am not that much interested in knowing in that precise case why they invoked or not such clause. What interests me is really how you have a very complex, long, I suppose that everybody drafting the contract say, oh, we might add one or another. But my question is really how you reconcile the text of them, not specifically discussing this case, applying them or not.
En mi experiencia,
In my experience, the result of this drafting is born of all the experience that PEP has had in connection with the performance of the contracts. Everyone suggests grounds that they feel comfortable and on which they can rely if they want to rescind the contract. There may be contradictions, yes, but what is very clear to me is that what PEP seeks to do is to be fully covered. That is to say, if under any situation whatsoever, it can rescind the contract. We talked about the shoemaker's box, right? Perhaps they say, okay, if something else comes up, I still have subparagraph F. I think that this is what these contracts and these provisions do. Any matter that may be determined by Pemex as harmful to its interest, any of those things will allow Pemex to rescind the contract.
But again, we are speaking of the FAO deal. I suppose FAO deal is a
yes,
worldwide expression. We're speaking of FAO deal. So maybe let's forget even F. But you have S and you have R. S says you can make an end to the contract if you have not complied with your obligations. R says, or you can also put an end if you have made the 16 times you have not complied with the work order. How can you give an FAO deal to S if in any case you have R? Or the contrary, to R if in any case you have S? Why? What is the substantial addition of R?
I think that in light of S, R didn't really have any effet utile, any kind of practical effect, because under S, only one would be necessary. We wouldn't need 15. As to the justification of Pemex or of the contractor to draft a document in this manner, well, why did they write 15? Why not 7 or 5? I really don't know. I don't know if at the end of the day, the effet utile is that with only one breach under S, you could ask for the contract to be rescinded.
This is, I think, one of our big issue. Well, let's go to what? No, we have done with the FAO deal. I come back to a question which was raised also by Mr. Melsheimer and maybe also a bit by President Gonte. At paragraph 49 of your first report, you say that MWS and Bissell could have demanded to receive worker orders. You have partly answered, I think, but I would like to understand on which basis this could have been done. Was it because it was dangerous? I think you admitted that, discussing with the president. It was dangerous for them to do that. So is it realistic, or did you add it just as a possibility, but in the air? Which do you think it is practical? And if yes, what would be the legal basis for that?
Sí.
Yes. I think that given the fact that there was a contract that had a maximum amount and a minimum amount, PEP was obligated under the contract to issue work orders that ensured at least the minimum amount agreed upon. What happens, and this depends on the contract, is that because of the finiquitos, or because of the rescission, that matter was modified. In the specific case of 803, when the parties signed the finiquito, the contractor does not reserve any right to claim additional amounts arising from the non-used amount of the contract. In the case of 804, the contractor did reserve its rights to claim up to $22 million. However, the civil complaint was dismissed, and they did not go to the administrative courts to try to get those $22 million. They waited 3 years to do that. This really strikes me, that they took 3 years to go to a different court, because I think they created an administrative act to be able to stake a claim when they had done nothing like that 3 years before. I think that PEP did have an obligation under the contracts to at least use the minimum amount in the contracts. And this, of course, was amended after the finiquitos were issued. In connection with this paragraph 49, specifically speaking, what I seek to explain here is that, well, in my humble opinion, undoubtedly, the complaint would have been admissible, at least in connection with the utilitarian component of it. The services were there. The $22 million included expenses, and there were many issues that were additional to utilitarianness. So the contractor thought that there was utility derived from the performance of the contract. So I think that the contractor had the right to do this on the basis of the fact that the contract had a minimum amount and a maximum amount. I hope I was clear, sir. If not, you can ask for clarification.
So, but I'm not sure I was clear in my question, because I didn't want to interrupt you. But my question was more limited. It is just to understand why the claimants would have performed the work. I am only on your paragraph 59. Would have performed the work which were not requested, while they had a right to have the minimum. This troubles me when I read it. So why does Mr. Azali writes it? There is no. It doesn't change. It complicates things. It makes things terribly uncertain for the claimants. While, in principle, reading what you write elsewhere, they have a right to have the minimum work orders.
Sir, let me.
Compensated. So.
Sí.
What did I say? I said where you? Yeah, they have a minimum work orders. They can be compensated for the loss of absence of work orders. So why would they execute work orders which have not been given? This is what you say in 59. That's not a central issue, I think. For it is more an issue for what you wrote.
Este párrafo 49.
Paragraph 49 was reviewed and reviewed over and over again when we issued this opinion. My point here is that I thought it was complicated to maintain that if PEP failed to issue a work order, well, it was complicated to have PEP pay for works that had not been executed, because we're talking about public resources. So we had minimum amounts and maximum amounts, right? So we had to reach this utilitarian component, as I said further down in my report. I agree with you, sir, when you say that insofar as there is a minimum amount and a maximum amount, the contractor did have a legal, clear expectation that at least the minimum amount of the contract was going to be complied with.
Fine. Now, another question on a different issue, if I find it somewhere. Finiquito. I have listened with interest all which was said, but I wonder if it is that important, because whether to know whether the finiquito is part of the contract or is not, whether it put an end to the contract or not, I think that there are a lot of other possibilities. For example, I think that at least it's true for treaties, which is more familiar to me than contract world. When you put an end to a treaty, you cannot put an end to the settlement clauses. So I think that whether the finiquito put an end to the contract or not, the settlement clauses are still in force. I also think that if you take 803, it provides for end of performance, which is something different from end of the contract. I think there are a lot of possibilities, and really, I just want to say that I am a bit troubled by the importance which is this the nature of the finiquito has done. I don't see really what is the concrete difference, whether you say it is part of the contract, it is not part of the contract, it puts an end to the contract, it doesn't put an end to the contract. If you could elaborate a bit on that, I would be grateful.
Of course, Mr. Co-Arbitrator. I think that the importance of finiquito has to do with two issues. First, once the finiquito is issued, the rights and obligations under the contract are reduced to the agreements made in the finiquito. If, in the finiquito, I waive payment of the amounts that were unused in the contract, then I cannot claim those amounts later on. It is a kind of settlement, and what the parties provide in the finiquito, well, that is what's going to be used to govern the relationship between the parties. From a procedural viewpoint, I think this is important. The legal nature of the finiquito, and we have discussed this, indicates that a finiquito is an administrative act. So there was no doubt in my mind that the complaint for 803 could not be put to a civil court. It had to be filed with an administrative court. What PEP says when it is called to the trial, well, it called into question the jurisdiction of the civil court. It said, the contract and this finiquito that governs the relationship between the parties is administrative in nature, and it must be heard by an administrative court. However, the contractor took 5 years to go through this civil proceeding. I'm not going to opine on whether the contractor acted correctly or incorrectly, but what I'm saying is that the nature of the finiquito is that it is an administrative act, and this is relevant for the rights and obligations in the legal proceeding, and also procedurally, it has a bearing because it has an impact on the legal proceeding itself. The contractor itself recognized that the finiquito belongs in the administrative court world because the rescission that led to the finiquito, that was put to the administrative courts when the complaint was placed.
15-minute break. I think we are close to the end, but later on there will be some housekeeping issues. So, and it's almost 2 hours since we started. So we'll make, you will continue, and so let's restart at say 11:10. So we restart everything on time. So, Alain, if you want to continue, please.
Yes, just probably not for long. Just one last point concerning finiquito. The possibility of a finiquito, is it, again, I don't speak of these one in particular, the possibility of a finiquito, is it a sign that a contract is administrative, or can you find the finiquitos, the possibility of finiquitos in contract which are not administrative, which would remain civil in spite of having a finiquito clause?
En cualquier tipo de
Under any type of contract, you may establish a finiquito. An example, a lease contract, whereby the parties decide that they are not going to continue to lease the property. A finiquito is signed, the contract is terminated, the balance is paid, and it is terminated. Finiquito invokes the end of the relationship. Now, in the case in particular, since the Pemex law and its regulation compels the signing of a specific finiquito, we have been talking about this finiquito document that is based on the law. But the finiquito name per se exists for private contracts as well as administrative contracts.
By itself, it's not exorbitant du droit commun, not exorbitant from...
De acuerdo.
Okay.
Yes.
Two last questions, but since they are very general, maybe we will have to decompose. And these are the questions which were asked to your colleagues the other side. First, does the Mexican law apply the stare decisis issue and stare decisis principle, and is it a strict one or not, and is it hierarchical or horizontal?
For a criterion to be binding for the lower courts, it should be case law. That is, there are 5 criteria that endorse that such situation should be resolved or settled as previously decided in this case law. But now it is the Supreme Court and also the collegiate courts, the ones that issue the criteria that may end up being compulsory or binding. Hierarchically, there is no obligation to comply with this. Let me give you an example. If a court from the First Circuit Court says that something is green and a Fifth Circuit Court says that something is red, both are equally valid. Now, you ask the Supreme Court of Justice to indicate through a counter-argument which of the 2 criteria should prevail. And the Supreme Court issues a counter-argument to that thesis, saying whatever the First or the Fifth Court said should prevail. And I think this is similar to what we see in the U.S. The various circuits may reach different opinions, and that gets to the Supreme Court of Justice that at the end of the day decides which of the 2 is the proper one.
To be stare decisis, it would mean that the ground for decision would be compulsory. Of course, in each case, the Superior Court imposes its view to the inferior courts. This is crystal clear. But I suppose that when you have jurisprudence by the Supreme Court or by another, you have some decisive, I don't know how you call them, but you have some leading case, and the courts feel obliged or do follow usually the same, although there is no hierarchy. Although if there is a hierarchy, I don't think we can speak of stare decisis, honestly.
Cuando un criterio
When a criterion becomes case law, it becomes binding and compulsory for all of the tribunals, for all of the courts. Now, as long as a criterion has been endorsed by the Supreme Court, and it usually requires 5 precedents along the same lines, it becomes compulsory and binding for all of the courts. At any rate, it is common practice in Mexico to enforce with a specific court some criteria that have been handed down by the Superior Court or by their peers to enforce a case. So the various criteria are cited that may or not be compulsory to lead the judge to a favorable or unfavorable decision based on the interests that are being presented.
Where can we find the 5 criteria? They are enunciated in a law?
Sí, ley de amparo.
Yes, the Amparo law, the organic law.
I have read it.
Y también en la ley.
And also in the organic law of the Federation. I imagine that the Secretary of Economy may refer to that in their post-hearing briefs, but that's the source.
Okay. And you confirm that at the time when the first claims were introduced, there was no clear precedent saying you must go to the administrative or you must go to the civil branch.
Es correcto, señor árbitro.
That is correct, Mr. Arbitrator. There was no compulsory, no binding precedent that bound the parties to resort to the administrative or civil courts. The discussion was about the right jurisdiction. What jurisdiction was the right?
Question or a series of questions. You also confirm that the Mexican judges, both branches, I understand, accept the idea that cura jura novit, which my interpretation, at least in this case, means that they can, by themselves, find a ground for a decision, even if it is not invoked.
Sí, señor.
Fine, thank you.
Yes, sir.
Le voy a dirigir mis preguntas en español.
I will be asking the questions in Spanish. The first one is an evidentiary question, and the other one is more of a substantive question. I was a little bit troubled with what you said in connection with footnote 110 and the statement at 87 in connection with this inclusion of new facts to the complaint. And if you look at the end of your document where you see the list of documents that you attach to your second report, JAH 86 says inclusion of additional items to the complaint for the annulment proceeding. It is a very clear title, And in your direct examination, this is the annulment title 5403-19-17065. But I only saw two other inclusions, that was JAH 23 and 30. And once again, the description is quite clear. There is a reference to the chapter and the proceeding. My question is, how could you, at footnote 110, how could you have identified that this was an inclusion of additional items if you were not familiar with the document? How could you determine that it was an inclusion of additional items to a specific case if you were not aware of the document, honestly? I think it's troubling. Mr. Arbitrator, the analysis and the documentation that we received was quite extensive. First, we printed what we had, and then we organized it. We understood 5 proceedings of a different nature. We added what was understood by the contracts, the finiquitos, and also the part related to 809 and the case law criteria. So it ended up being a very extensive volume of documents. The only explanation that I can honestly offer you, that as part of all of those documents, certainly an inclusion of additional items to the complaint was missed, and when we were linking documents, we misunderstood a document that belonged to a different proceeding. When we reviewed the documents, we saw that the document did not exist, but the only authentic explanation is that this is a confusion on my behalf, and given the ample number of documents today, it's very easy to say 803, 804, 821, 809. But back then, given the number of documents we received, it was not that clear, and it took us a long time to control the situation, to understand the subject matter. And as part of that onslaught of documents, there was a mistake. I understand it in connection with footnote 110, but at least when I am an expert or as a lawyer, my paralegals give me the documents, but I do review them, and I see that there are not so many attachments from 67 to 88. These are not hundreds of documents. Do you verify the exhibits that you attach to the opinion? Clearly, because I check the content to verify that the paralegal that does not understand the case has not done something incorrectly. Do you do the same? Yes. And at the end of the day, when we read it for the final time, when we verify, we clearly see, yes, inclusion of additional items, and I missed it. There is no other explanation, and given the number of documents that we had at hand, that we had to review in a brief period of time to issue an opinion that would be solid, substantive, and that helped the tribunal reach the decision that they need to make. Now, moving on to the substantive issue. In your second report, this is something that was also mentioned by Professor Pelé on the finiquito and the nature of the finiquito at paragraph 44 of your second report. You describe 821 is no longer in force, and it cannot be of any effect given this decision, and you're referring to the criteria that is considered to put an end to the effect of the contract, the termination of the term of the contract, and also that the settlement be formalized, and in the event that there are balances in favor of the parties until such amounts are paid, are not applicable in this case, since the termination of the contract was precisely actualized by PEP's determination to administratively terminate it. I had several questions in connection with this. And I remember that in the cross-examination you said that the formulation found, and we can show to the witness the document, are 43. And we go to page 33. I think that there were two situations that were mentioned at page 30, title 12, that says the closing of this contract will take place when the contractor, etc. And here it says, but any actions necessary to enforce their rights shall take place before then. And also you were read page 33 that refers to the validity of the contract. My question to you is, if I am looking at this in the right way as to the nature of the finiquito, I see that at page 33, the finiquito itself is referring to Article 76 of the administrative provisions. So I understand that is C15. Can he be shown C15 to the witness, to the expert? And can we look at Article 76? And the final clause under 76 that refers to the finiquito. Professor, I apologize. We're looking for the document. It's okay. I think it's in my presentation. It's R15, right? C15, CL15, CL15. Administrative provisions and state contracting. As I mentioned before, I am referring to this Article 76 because the finiquito itself is based on that article, and then at clause 18, so we're going to review that one too. In 76, the last paragraph refers to the fact that in case that the provider or contractor does not appear to the finiquito, the decentralized body will carry it out unilaterally. If I understand it correctly, and if we go back to the finiquito, this finiquito was issued unilaterally, correct? This is what we read in the finiquito itself. At this clause, page 33, it says, it is hereby stated that this finiquito document has been drawn unilaterally given Drake's absence. Yeah, this is not the one on the screen. We need to move on to 821. But this finiquito was drafted unilaterally, so it applies to, Article 76 applies. Yes, correct.
If we go back to 76, Article 76, I see that at Article 75, well, 76 begins by saying contracts for works shall be subject to finiquito. What Professor Pele said, the instrument of finiquito is applied in this administrative table on state contracting. And then it says, in order to certify the adjustments, reviews, modifications, or recognitions, and the balances in favor and against, as well as the agreements, conciliations, and settlements that are agreed upon, and to finalize or to conclude disputes that may have arisen. And then I read in Article 75, the previous article, it speaks of termination of the contract. And it provides various means by which it may be terminated. One is, say, in number 3, when there are causes that impede performance of the contracts and other grounds or causes. And then it's interesting that in 76, third paragraph, it says, if appropriate in the finiquito, the supplier shall be asked, and so forth. And it says, and in general, those necessary in order to endorse the obligations that should be carried out subsequent to termination of the contract. My question for you is, if I read these provisions, 76 together with 75, the finiquito is not the instrument that establishes or concretizes the termination. Is that not so? Seeing as it's the article that follows 75 on termination says that the finiquito may be used and that in the finiquito will provide for solutions or, well, whatever needs to be done after the termination that is provided for in the finiquito. I understand that the finiquito ends the contractual relationship as between the parties, but it doesn't end all the relationships originally stemming from the contract. The finiquito, well, I think the most significant word is a settlement. It settles what was going on in that relationship. And as of the finiquito document, the relationship between the parties will be governed by what is agreed upon there. Amounts owed may be determined, rights may be reserved. Indeed, one may terminate any relationship whatsoever as between the parties from that point on. What these docs, these regulations seek is, or provisions seek, is to establish some uniformity to the way in which the relationship between the government and contractors should go forward and should be considered terminated, establishing a general framework for such acts. So as from the signing of the finiquito, the relationship between the parties is governed by what is agreed upon therein. This does not stand in the way of there being other acts as between the parties. We saw this in the case of 809 with the document extinguishing rights and obligations, which was signed after the finiquito. It seems to me that it's clear that what these docs, these administrative provisions on contracting sought was to set a framework on the basis of which the relationship of the parties will be understood to be based once the finiquito is signed. Understood. Perhaps we could go back to R43. And it says halfway through in this finiquito, and then it distinguishes Clause 18 of the contract. The contractor loses the right to each and every one of the resolution procedures and so on, and then you read, except for what is established in operative paragraph 4, which is the rescission. And if you go to operative paragraph 4, which is R14, and it's not surprising what you see there is that one is informed of the rights to appeal. This is R14. And in the operative section at the end, operative paragraph 4, it's at the end of the document. PDF page 47. Is given notice of the right to a hearing and the right to visit and inspect the document. So the only reference I read in the finiquito to the rescission is that one must take into consideration, with reservation, is the right to be heard. But reference is not made to what you say for the purpose of the rescission in relation to the term of the contract. It seems to me, sir, that one must distinguish between 821, in contract 821, from which is where this finiquito comes from, the resolution has already been rescinded, the contract has been rescinded. Now, in one of the legal actions, I can't remember if it's the administrative or the civil one, the contractor generally cites or seeks as a precautionary measure that the finiquito not go forward, keeping it alive or making it impossible for PEP to adopt the finiquito. And so the finiquito, it does not happen until 2021. I think that's to give rise to the bond, payment of the bond. I'm just speculating here, but this finiquito certificate for 821 doesn't imply that rescission is as from here. The contract had already been rescinded. It seems to me that PEP should have been more careful in drafting certain clauses of the document and not use a boilerplate, which I think they had for the finiquito, that did not adapt to the particular situation of the case in view of the administrative resolution that we saw. But that doesn't mean that the contract was in force. I believe that Clause 18 spoke about it being in force until such time as there would be no debt stemming from or amounts owed stemming from the contract. So I would argue that it is an unfortunate drafting of this finiquito and any legal issue stemming from it. So you're saying that the drafter did a copy and paste and didn't adapt it. Doesn't it seem unusual to you that the document itself does certify a fact that we don't find in 804, which is that it is a unilateral act and the contractor has not come forward? That it says that quite clearly a few lines before and a few lines after. I think the two ideas can go hand, can both exist. One thing is that it did not adapt completely to the specifics of the case, and another thing is that certain particularities weren't taken into account. In effect, 804 was bilateral, 821 was unilateral. Nonetheless, it seems to me that they left certain paragraphs in that they should have deleted in light of the administrative rescission. I don't know if the person who drafted this was a lawyer, an engineer, or whatever, but in my humble opinion, they could have been more careful when drafting to make it clear what was sought from this finiquito. If I read the document, if I look at it prima facie, it clearly makes reference to these facts that the contractor did not come forward, and therefore it says one applies the clause 18. And if I go back to 821, if you could show the article from Contract 821 to the expert, at Article 18 regarding finiquitos, well, you know the contract. The contract itself provides for the situation in the event that the contractor does not appear, which is the last paragraph. PEP shall proceed, etc. And then if you look to the second part, it says the term of this contract will end when the settlement is formalized or the event that it results in balances in favor of any of the parties until the date on which the corresponding amounts are paid in full. That is a particular provision for a situation in which the contractor fails to appear. Correct, but it is not a situation that comes into play when there is a rescission. It seems to me that in the event of a rescission, evidently this situation has been addressed because there was a different way of interacting as between the parties in the finiquito. Nonetheless, the finiquito was issued either because of bureaucratic or administrative considerations. In this situation, the finiquito did not terminate the contract. It was the rescission determined by Pemex that ended the relationship as between the parties. I understand what you're telling me, but the document itself, the only thing the document does when it refers to the rescission is make reference to operative paragraph 4, which are the rights to be heard and the rights in respect of suspension. It doesn't make reference to other operative paragraphs for legal effects of the decision. Sir, I think the person who drafted this could have been more careful when they did so. I have no reason to defend or endorse drafting, which I find defective, that I believe does not address all the specific points of the dispute. Now, a general question about the finiquito instrument. If I understand properly, the finiquito is an instrument that really puts an end to the relationship between the parties, and that it must be read narrowly. Now, it's clear that one cannot interpret the document because it's a very serious act on the part of the parties with a view to resolving a dispute. Therefore, the interpretation of the text must be highly restrictive. Is that correct? The only note I would make is that it is not necessarily a dispute. I might have ended a whole contractual relationship and then I enter into a finiquito, but I agree that it should be read restrictively. Now, if one of the parties is reading the document, then they can rely on the document. In particular, that should be the case if it's a unilateral document. I agree with you, sir. Very well. I don't have any more questions. Thank you.
One additional question, but first I need to check with Mr. Melsheimer. It's about the footnote on GA 86 on the extension of the claim. The question is, that extension of the claim is the one you are looking for in Mexico or has nothing to do with it?
I don't know what Mr. Asali was referring to when he wrote those words. It could be he's referring to this document, which is what I'm trying to get an official copy of, which is called Allegatos in this proceeding. I see you shaking your head no, I don't know. But perhaps they were referring to this when they wrote those words. I don't know.
So it might or it might not. Okay. Y entonces mi pregunta al señor Asali.
So my question to Mr. Asali, following up on the question by Mr. Sterneman to understand the logic for discovering there, because you read paragraph 87, and it seems that you've read that document, the amended complaint, and then there is a note that makes reference to that document. And my question is, did you at some point realize that reference was being made to a document that you hadn't read? It was miscited. There was no such amended complaint, and I had made a mistake on referring to the specific proceeding. And once we realized it, well, we recognize it. I apologize. That document does not exist. I did not review it. It's poorly cited, and it's poorly indicated in the respective paragraph. So when numbering documents, what is your technique? To number them before you verify that they exist? So an amended complaint, I'm going to give this the number JAH86. And then when you went to attach it, you realized that that document didn't exist. No doubt I took the wrong annex of another amended complaint. I considered it was the right one, and then I saw it was wrong. I reiterate, given the large amount of documents that we reviewed on the first and second occasion, I misnumbered it, and I took a document that wasn't the right one. On realizing this, we noted it, and we discussed it in the presentation. You'll see that I make reference to that document not existing. It is poorly cited. It's not properly there. It was a mistake. In other kinds of arbitrations, such mistakes are made. Everybody makes them. But then you add the document and you see that it doesn't coincide with what's said. And so there is a correction of the annexes or the exhibits. One says what was submitted as document or Exhibit 86 is not the appropriate one, and then one replaces the proper one. So here you made reference to a document before you had it in hand. Not before I had it in my hand, because I never had it in my hand. I understand that it doesn't exist. What we're I'm talking about, that document does not exist. It was not properly cited in the cut and paste that you make. There's an erroneous reference. That document doesn't exist, of course, but the problem is you make an erroneous reference not only in the footnote but also in the text. So reference needs to be made to the fact that it suggests that you read a document that you didn't read. I left in an expression that should have been deleted because it did not correspond to that paragraph. What do you mean it didn't correspond to that? The amended complaint didn't correspond to that proceeding. There were several proceedings. We read 2 additional amended complaints. That reference should not have been there, and therefore the cite. So you were referring to an amended complaint from another different procedure. Yes, and it stayed there as a matter of mistake because of lack of care. And once we realized it, the opinion had already been submitted, and then we followed up noting that it didn't exist, that it was mistaken. And what other amended complaints were there in other procedures? Do you recall? There were 2 previous ones. Yes, you cited them. So it was a mistaken reference. Okay. I ask Mr. Bonfilio or claimants any
Tribunals, either party? No?
Just a couple questions about the finiquito for the 821 contract, since we were just on it. Mr. Asali, you're aware that the company Fianzas Dorama rejected Pemex's first attempt to claim against the $41.8 million Dorama bond because there was no finiquito, right?
No estaba al tanto. No.
I wasn't aware of that. I did not give an opinion on the Dorama bond. The opinion I've given, or the information I have, is what I've heard here in this hearing. I don't know about its non-acceptance.
Agree with me that Fianzas Dorama rejected Pemex's first attempt to claim against the $41.8 million Dorama bond because Pemex did not have a finiquito.
No tengo motivos para pensar que...
I have no reason to think that what you're telling me is wrong. I am not familiar with the substance of the question.
Okay, y por su parte, señor Bonfiglio.
And Mr. Bonfilio, thank you, Mr. President. It's 2 very simple questions based on what the members of the tribunal have been asking you. And for this, I think it's important that we go back to RZ 39, which is the annulment proceeding of 2017. And give me just a second, we'll be able to project it. Here you see the first page of the judgment in the annulment proceeding, and it begins with the section on findings of fact. And if we go down, you can see the background, or rather the precedent cited here. Now, my question for you, for the benefit of all of us here, is based on your analysis of this judgment and of the documents that were part of the annulment proceeding, of 2017. Once again, do you know whether Drake Finley, as the plaintiff in the annulment proceeding, filed a amended complaint in this? No, it did not. And once again, to support the tribunal and the parties, could you give us a definition of amended complaint under general procedural theory? An amended complaint is an act by which some matter that is not made explicit or that is additional to the initial complaint brief supplements the cause of action, which in this case is a claim against the authority administrative proceedings. So the amended complaint is filed in order to add to the facts in a proceeding so as to allow the party to defend itself from all of the accusations made. It is presented at the outset of the proceeding. It cannot be presented subsequently. And it normally means that there was some supervening or unknown act that enables the moving party to file before the adjudicator all of the various elements of its argument. One cannot amend a complaint just because one wants to. Rather, the amended complaint must be justified normally based on supervening facts that I had no opportunity to learn of or to set forth initially in order to supplement the claim. And as follow-up, the respondent in a proceeding where an amended complaint is submitted, would they have an opportunity to answer that amended complaint? Always. Okay.
Señor Presidente, no
Mr. President, we have no more questions. Thank you very much for the opportunity.
Señor Asali, puede ya.
You may stand down now, Mr. Asali. Thank you, President.
Just to wrap up this hearing, then it's now clear that the tribunal will need some limited documents. The first one is some, not all, but some key documents which are exhibits, which are only in Spanish. We will want them to be in English, translated in English, not to make your job too burdensome. The tribunal will specify probably those that we really need.
Just to explain, up to now, since sometimes I needed to have the translation, I didn't find it. I found too complicated to ask the claimant, so I used DeepL and I translated it on DeepL. But if we have really to discuss something precise, yes, I'm afraid you will have to. I'm sorry for that, but I really cannot seriously discuss documents which I cannot read.
Si pudiera añadir algo a eso, señor Presidente.
If I could add something to that, Mr. President, there are some laws that are in the record that have not been translated in full, particularly certain articles. So on behalf of the respondent, and no doubt we can all cooperate here, we could translate any provision of those laws needed, and you can rest assured that if there are any other documents to be translated, we will do so. And in particular, we recognize that our opening argument and the presentation by Mr. Asali are in Spanish, and we will also provide a courtesy translation for the benefit of all. Thank you very much, Mr. Bonfiglio. I think that in order to, what I was saying is to limit the burden for you of having to translate all the exhibits, perhaps we, the members of the tribunal, can take a look at exactly what are the ones that we need to get in English, and then we would let you know.
As I told you, I think the tribunal would like to have some additional information on the organization of the group of claimants and also of the who was who within PEV and who reported to whom. So expanding essentially the dramatis persona that you submitted, which was not detailed enough. So those are. Then we have the warning from Mr. Fleischmann that at some point, Melsheimer, again, there's a story by a British author, and that keeps coming to my mind. Is why Mr. Fleischmann did raise her prices, and but again, my apologies, Mr. Melsheimer. You said that you might at some point request for the submission of additional evidence if you find it in Mexico. So that's
We will.
okay. And then when you do, we will give, of course, the opportunity to respond and to react, and the tribunal will consider that seriously and come back to you. Then we have also pending the question of once the procedure is finished, so once all these intermediary ancillary things have been sorted out, when the post-hearing briefs and the submission of costs would take place. And just, again, do you have a sort of indication of how many weeks or months would you need after the procedure is closed for you to submit the post-hearing briefs, just for the tribunal to have a sort of ballpark figure of dates?
Sí, señor presidente, gracias.
Yes, Mr. President, thank you. It's been a complicated week for the parties, and I can very openly tell the tribunal that we are continuing to talk to try to reach further agreements and then present them to the tribunal for its consideration. I think there are several milestones that need to be worked out. What comes to mind, and certainly Mr. Melsheimer will be able to add, and one is preparing the charts that the tribunal needs. And I think that in tandem with that, we, the parties, will have to review the transcripts of the hearing. Now, once the transcripts are reviewed, this will trigger a period for us to prepare the post-hearing briefs. Our suggestion is also that the post-hearing brief include the answers to the list of questions that the tribunal will send the parties. And after submission of the brief, of the post-hearing briefs, then finally the parties will be able to submit their statement of costs, following the logic that we won't know the expenses incurred until the end. And providing a figure, well, we had proposed 90 days for preparing post-hearing briefs to be counted from when the transcript is ready. That is something that we are discussing with the claimant, but I'm going to give Mr. Melsheimer the floor so that he can add or correct what I've said.
Okay, because, again, we still have that. Will the court allow us to take pictures of a file? That issue is still outstanding, so that kind of affects things. It would be very helpful if people do have a copy of that document. It would be very helpful and expedite this process tremendously if they shared it, or if they would offer some cooperation with the administrative court to obtain that document. I think that would expedite this entire process, and so we could not further delay it.
Señor presidente.
Mr. President, I should make a few clarifications, and I need to go back to some of the points that were discussed yesterday. We have no clear idea as to what the document is that the claimant is referring to. That's point number one. Point two, it was apparently submitted by Drake Finley in the nullity proceeding of 2017, the annulment proceeding. They should have the document. We don't understand why we need to wait for the Federal Court of Administrative Justice to provide it. Third, 2.5 years ago, the procedural calendar was established, and the claimant, on their petition, asked that the request for documents phase be before submitting their memorial. Fourth, we have no involvement whatsoever in the Federal Court of Administrative Justice. So, if the claimant, years later, decides to try to submit to this tribunal because it considers that there are extraordinary circumstances that allow it to do so, this in keeping with procedural order number 1, well, first, they should know what document they're referring to. Second, they should have it. Third, we're very, this is long after the document production phase, and I need to use the word from yesterday, the claimant's request to submit new evidence or new documents is become systematic in this case. And I think that it's gone far enough, particularly because 2 weeks before beginning the hearing, we faced the need to review hundreds of pages, and I don't think that's right.
One question to Mr. Mearsheimer. I understand that you have the document, but you need some stamped document. Is that the case? Or
The copy that our lawyer sent to us that has been verified with the court by one of my colleagues in Mexico City is sitting in my hands right here. I don't know if that's acceptable or not. I think you would want to have a file stamp copy or something to show that it's official. I'm happy to do a declaration that one of my colleagues inspected page by page. What I didn't hear just now, and I understand the pleas, but what I didn't hear is if the Secretary of the Economy currently has in its possession a document called Alegatos, which was filed before the administrative court. If they do, it would certainly expedite the process of submitting a petition to you all, asking for mercy, if you will, if we can introduce this document, and then we can go about getting a determination from you.
Si pudiera agregar algo, señor presidente.
If you allow me, Mr. President, I think it would be very efficient, very productive, and it would be perhaps a good thing for the claimant to share with us a document that it has at the time in a spirit of cooperation. We would like to be cooperative and efficient, but honestly speaking, we don't know what document they're making reference to again, and I would like to underscore this. Drake Finley was the company that started the annulment proceeding in 2017. The document has been stamped and submitted, and claimants' counsel should have that document. I'm not clear as to what this discussion is. If that document can be sent to us by claimant by email, we're going to see it. In Spain, we say the best notary public sometimes makes mistakes. So reputed experts like Mr. Asali has made a small mistake. Perhaps Drake Finley sent the document that it didn't keep, a sealed copy or a stamped copy. Perhaps it's a relevant document.
The criterion of my colleagues will reflect on that. In the meantime, you exchange the drafts. You come back to us at some point, and the tribunal will decide. Well, other than that, is there, Annelise, colleagues or parties, anything for us to consider, or we can just close?
Would it be helpful for you all to, if you have them, questions for us to raise or address in our post-hearing briefs? Because my preference is not to submit to you another voluminous document repeating what we've already told you.
Yes, you're right, and as Mr. Bonfiglio already mentioned, the tribunal intends to send to you questions for you on a voluntary basis to consider or neglect. So I don't think there is a need to establish any limit to pages unless you want so. I think each party should be free to plead. Other tribunals impose a limit. I don't think that's necessary unless you think so. Alain.
Well, I think no limit, but reasonableness is part of law on any respect. So this is one point. Second, small point, but Mr. Bonifiglio, you spoke of, you said when the transcripts are ready. Yes, they are virtually ready. I mean, you have everything. Of course, they must be checked. But I think if we wait for you to exchange remarks on the transcript, and you say, "Oh no, this comma should not be here," we lose. And this, what I've seen from this case is that you are very good in doing with commas. So I really would think that we should say that when you receive the transcript, you can really start drafting your briefs, and there is no need to wait for that forever. And then in parallel, you can exchange your views. But really, I would not wait for transcript being totally finalized, if you accept that.
Thank you very much for your comment, Professor Pillay. I think that there are two things that must be considered. This must be considered by the members of the tribunal. Both claimant and respondent wants the transcript to be as close to the audio file as possible. And for that, you need to review the audio file and what has been written in the transcripts. Also, I think the procedural orders have established a period of time for the review of the transcripts. And third, because of efficiency and transparency, of course, the transcripts need to be prepared in the best way possible. What we do in our practice is we read the transcript, checking it against the audio file, and our proposal is for claimant to do the same thing. For example, the English version, and then we do the Spanish version, and then we can do a cross-reference of the versions. And if there are disagreements, or if we do not agree as to the contents of the transcript, we would put that to the tribunal. But at the end of the day, the procedural orders from the tribunal have established certain terms. In this case, 45 days. That's what my colleagues are telling me, 45 days. This is our daily work. It is very important for us for the transcription to be as perfect as possible, without prejudice, of course, to the fact that the stenographers have done a stellar job.
Hearing to a close, unless you have any final point. The main point is for a tribunal to express its thanks, first of all, to Annalise Fleckenstein, who has been supporting us throughout, to our stenographers that we are seeing here, Ms. Don Larson and Ms. Paul Pellissier, and someone who we haven't seen but were behind the screens, Silvia Colla, Daniel Giglio, and Charles Roberts. I think they have made possible for this hearing to run smoothly. And on the part of the tribunal, we want really to thank the parties for the way in which, while there were occasional blares of tension, natural in this type of proceedings, you have behaved in a most cooperative way with the tribunal, and we are grateful for that. On that note, I declare this hearing closed. Thank you.
Muchas gracias, señor presidente.
Thank you very much, Mr. President.
You mean ARB?
Oh, sorry. It was a pleasure.
Thank you very much. Bueno, encantado, es un placer conocerle personalmente.
Gracias.
Thank you very much.
Un placer.
Un placer.